In 15 minutes, I do hope, the Minister of Justice is going to join us, Alexander Konovalov. And he asked not to wait for him, and he asked us to start our work without him. I'm a justice of the Constitutional Court of the Russian Federation. My name is Gadzhiev, and my colleagues are next to me. They're going to help to organize our work. And if I may, I would like to deal with some logistical matters. We're doing something at the head table also. Organizational matters are such that our work is going to last for 2 hours, which means we have to be brief, 10, maximum 15 minutes each. After the presentation, it's possible to ask a short question. And of course, we'll have the free-flowing discussion after our presentations. Naturally, in the framework of our schedule, we have to be decent about time frames. And Alexander Konovalov was supposed to be the first one, but he asked us to start without him. I will be arrogant enough, and I will start our work. I will try to determine the subject matter of our discussion, if I manage to do it. And I believe that I will start with the following. The idea of law as law itself is similar to mathematics and poetry at the same time. This is a very old idea, and that's what the philosophers of law noted in the 19th century and in the 20th century, and our Russian philosophers also were talking about the imagery of law, images of humans, of entrepreneurs in law, and of course this use of images brings together philosophy and law and poetry. And equally, it's possible to find some similarity between mathematics and jurisprudence, although they seem to be just the opposite matters. Not at all. And now I recalled it because I remember that one young poet, he was inspired, and in the middle of the night he wrote wonderful poetry about love. And in the morning he got up and and he tweeted the following: "I wrote poetry about love." I practically exhausted this subject matter. And why I remember it? Well, because in jurisprudence we also have certain subjects that, as love itself, are not exhaustible at all. And one of such issues, one of such topics is the idea of law. And I believe that we can state that, first of all, the idea of law is not to be exhausted, ever. And secondly, when we discuss the idea of law, this idea is very national in itself. And I will explain. Yes, we live at the time of information technologies. Naturally, our time is the time of globalization, and it's quite natural that these two factors make national law almost useless. I'm exaggerating here, of course, I'm exaggerating, but when we look into the future, we can think that this process is going to gain momentum because the internet, high-tech development, well, national law overcomes it all. Does that mean that this risk factor, if we look at it, does it mean that now it's the twilight of national law? And national law doesn't have very good future. I think that it's not so. And I am convinced, and this is my inner conviction, that for a very long time national law is going to be part of human culture for a very long time. At least I'm talking about the foreseeable future. And I'm talking about this feature of law and this connection with the national culture, because today the Chief Justice of the Constitutional Court was talking about the same thing. He talked about the connection of law with the social norms, social provisions that make part of the culture of the society. And if I understood Professor Zorkin's words the right way, he talked about different types of context for law. Yes, in old times when well, it was the time of German pentectists, and the codes emerged. And the norm was always connected to the provision in the general part. And this is a very simple technique for the lawyers to discover the context inside the law and inside the legislation. By the end of the 19th century, beginning of the 20th century, there was a different context. And we can say that the judicial norm, legal norm, is in the broad context of social norms and all the cultural norms, cultural provisions existing in the society. Culture, this is the memory, non-genetic memory of humankind. And of course, in different parts of the globe, it's different. We can say that these cultural norms are not similar. If they're not similar, if they're not the same, they're not identical, that means that every nation has a fate of its own. This fate, this life for a long time in the same land is of great legal significance. And I believe that it's one of important categories of constitutional law. And when we look at the fate, at very long life in your land, there is some kind of a right of peoples to have their own fate, their special nature. And I believe that Valery Zorkin mentioned just that. And once again, that was the logic of Valery Zorkin. He said that if there is the right to have your own fate, that means that there is a right to oppose the people, have energy of opposition. When this special nature, when they try to somehow abolish it, well, if there is some energy of opposing it, yes, it does exist. Should it be recognized? Yes, it should be recognized. And my understanding is such that the law, the legal provisions, make not just some logical forms, and these are not just words you can find in books. This is not some bookish law. This is the live law, a live law, that what was mentioned by Ehrlich. And when we discuss this live law, we're talking about polycontextuality, when the law is in interrelation with the multiple cultural norms. And I believe that I read about that idea in the books of Oskar Spengler when he mentioned Roman law in brief. And if I'm not mistaken, I try to recall it. He mentioned that in the Middle Ages, European lawyers, medieval European lawyers, used just logical forms that they took from the books of Roman lawyers. And he asked the question, does that mean that they brought new life into old Roman law? No, it's impossible, because a legal provision is to be correlated by the thinking of a specific human living in a specific society, in a specific historic period of time. And it takes maybe 100, maybe even less, 50 years. The mindsets of people change, and the provision is connected with this mindset. But when the person is a debtor and pays the debt, most probably the idea is not to follow the law. This is the duty of this person. This is something which is acceptable in the society. It's one of cultural norms of the society to pay your debt. We lawyers, we always exaggerate the significance of legal provisions. Their significance is not so great. It's not absolute at all. And I believe that no matter what kind of new constitution we have, it could be state of the art, it could be brand new, but it's new only in part, because this new constitution is given to the people with established mindsets. And the constitution is not just the set of legal norms, but the constitution also is the codification of the links with the past of these people, with the culture of these people, with the traditions of these people. And there are many different words and Latin word mores, but these words are not capable to just convey all my ideas. I believe that the idea of law is not to be exhausted. It's a national idea, profoundly national. If it's not so, I ask our participants to make their comments. When it's necessary, please find the weak spots in my very short address. Thank you for your attention, colleagues. Alexander Konovalov is not here yet, and in this situation, I believe that I must give the floor to our guest, Ms. Deubler-Gmelin, professor and the former Minister of Justice of Germany, if you don't mind.
Thank you so much. And thank you all for inviting me to this very interesting, conference. I have to say, I feel really at home. Because, we Germans have the tradition of the so-called German days of law professions, meaning lawyers, academics, politicians, members of parliament, and of course judges and justices meet in regular times to talk about interesting academic and very practical problems. And I feel that this international legal forum is a good idea of changing ideas and doing things like that. And as the moderator and the chairperson has mentioned, I have my experiences in very different legal professions. I'm an academic, international law and constitutional law of the Free University of Berlin and the Tongji University of Shanghai. I'm a consultant in international constitutional matters in different countries, last in Tunisia. And of course, I'm a lawyer for, well, I have to recount that, for 35 years now, and a member and long-standing member of parliament and Minister of Justice. So it's not only the appeal of philosophy and idea of the law, which you just presented in a wonderful way, but what's interesting for me, but it's the idea and the implementation of law, as you will imagine. So I'm very happy to be here, and I this morning took the opportunity to listen to the lecture of President Professor Sorkin. And I have to say that I was really moved about what he said. His, let's say, mentioning, yes, his confession to law as a foundation and fundament of every civilized society was very moving indeed, I have to say that. And I absolutely share this attitude. I absolutely share this point of view. But, and to now, of course, I have to mention that this attitude does not prevent oneself to talk about the differences between, let's say, the national approaches and the international approaches. And of course, the first question will be, what does belong to the idea of law? What does belong to the law as an element of every civilized society? You know, as a German lawyer, well, I'm coming out of the tradition of Roman law, of continental law, of the European legal education, and of course, we had our big share, as you just mentioned that, Chairman, of, let's say, legal philosophers and great people in the century of Enlightenment. I only want to cite Kant, his idea of law, the idea of a good state, the idea of eternal peace, and in international law. And you know quite well that the French Revolution and the idea of the contrat social and the idea of human rights influenced this European continental way of thinking highly. And perhaps you will know I'm a social democrat. And so it will not be, let's say, very strange to you when I say that the fight of social democrats for 150 years, starting in the 19th century, was to get the idea of enlightenment, of human rights, the idea of law for everyone, meaning for the workers and their families, to include them into society and to create a society ruled by law. Now, when I may, I'd like to say that, of course, having good legal philosophers, even poets, and I could cite Friedrich Schiller now, who had quite a lot of, let's say, good legal thinking in his poetry, does not save you from fallbacks into utter barbarity. You know that the fascism, time of fascism, was the opposite of law, the opposite of human right. And we, my generation of Germans, we, let's say, profited from being freed of this, let's say, fascist ideology. And I know quite well that Russians had a wonderful share in this situation. But I have to say, this gave us quite additional experiences about the idea of law and the implementation of it. And to the question, of course, what belongs as essential elements to the idea and the implementation of law. And let me just say, it is, of course, the rule of law, with all that elements. I know you know them, so I don't have to refer on that. It is the holistic idea of human rights, as it was mentioned in the General Declaration of Human Rights in 1948, meaning there is no priority between liberal human rights and social, cultural, and economic human rights. So the idea of saying, well, we give the people one, but not the other one, or it's dependent that the standards of human rights have to differ along the society and its development is not mine. And it's not the holistic idea of the Charter of Human Rights of 1948, which is, of course, a part of the European Convention of Human Rights, and it's a part of the German constitutional rights. But, of course, we know quite well, it is not only as much as I share your idea that law is a national thing, it's not only that. I think we are in a century now where international law is most important. And I only want to mention the UN fora of international law, not only of lawmaking, but the international fora for human rights, where your country, my country, and all the other countries are members. And I'd like to mention the United Nations Human Rights Council in Geneva now, and its procedures. And if I should mention what is the difference between the idea of law on the national and the international level, it would be that there is a high and a very serious discussion going on. What is the influence of international law thinking to the national level? And what is the influence of the national level for the international one? And I'd like to give you, and then I'll stop, if I may, Chair. My idea is that the universal human rights standards must be the same ones. But the question of implementation is dependent on the national culture, religious, historical background. But I think we have to fight for the standard setting on the international level, as much as I know that, let's say, sovereignty on the national level is touched by that. Let me give you a last mention. You see, Germany is a small country. It's big in economics, but it's small. If you compare that to our Chinese friends with their 1.5 billion people, our population from about 80 million is a very small one. And I know quite well that, let's say, sharing sovereignty on the international level for the standard setting is easier for small and medium countries than it is for big ones. And you can see the same questions arising with the United States. You can see that with China. You can see that with Russia. If you look, let's say, to the International Criminal Court. But I hope we will be able to discuss this later on. Thank you so much.
Thank you very much, Madam, for your very eloquent contribution. Unless we have any questions from the audience, actually, this is a free time for questions. Yes, unless we have questions, I would ask, with your leave, to take Vladimir Legorda to take the floor. Thank you very much, my dear colleagues. I need to confess that I'm not a lawyer, and it is very great honor and also a little bit of an anxiety for me. Finding myself in this distinguished audience of lawyers. I probably would feel the same if I were facing a convention of physicists. But I know that when you have two lawyers, there will be three opinions, so I have a good chance not to be singing out of tune. I also hope I will be playing the role of Dr. Watson to Sherlock Holmes, who may not be asking clever questions, but would also get good answers. So my hope is that my very brief presentation will be a collection of notions pertaining to this conjunction of philosophy, law, and religion. These are the topics that are closest to me by my background and my current employment. If you believe I was too categorical, this categorical is not because I'm completely convinced that I'm true, but because I don't have much time to go into much detail. The very first statement I want to make in this context is the following example. If you take the Ten Commandments by Moses, the Decalogue, which are the law for quite a few cultures and jurisdictions, and if we ask which sort of maxims are more important, legal or moral or ethical, we see that these maxims are actually religious, and at the time of their origin they contain something that would become law and ethics. That shows the genetic link between the law and the religion. There are no religion-free societies. At least I hope that culturologists would support me. I believe all cultures were preceded by religion. So there is this very a close link. Then societies started differentiating between different phenomena, segregating economy, arts, humanities, law, out of this all-embracing religion. And it leads to certain conflicts. I may be wrong, but again, I warned you, I don't want to sound categorical. One of the conflicts in the modern day law is the fact that it is separated from religion. It's segregated from it, which might have been inevitable with the creation of secular society. I don't know exactly what is the universal interpretation of secularity, but it's also separate from the ethics. The European Convention of the 50s has mentions of the rights, but it is not in the later declarations. There are many very complicated topics that cannot be treated only through law. As a person involved in the issue of inter-religious links and ties, there are certain issues that you need to address, and you can't address through law only. You need to proceed from certain interaction between law, ethics, and so on. We've heard about a certain conjunction between universal and national in the legal culture. This is, of course, a very important idea, but I wanted to introduce in this discussion of legal culture. And this legal culture is not a knowledge of law or application of laws, but rather it's understanding. That is the notion of the culture that was introduced by Albert and Verda in the United States when they asked themselves why one and the same political institution work differently in different countries. It seems to be the same democratic institutions do not work in the same way in different democracies. And they talked about political culture, which is a set of certain and political values, orientations, affiliations that they thought would explain this difference of functioning of different institutions, which was referred to as the national element by our moderator. Now, by analogy, we could talk about legal culture. And is it actually something that we have already been discussing? You mentioned the interplay between the international and the national levels. In that case, we could talk about certain restriction of the universal international level. The interplay could be different. It's of course very contextual and dependent on the circumstances. Now moving on from legal culture in general to that in this country. It is apparent that domestic culture was following the East European Christian tradition, for which it was very important to differentiate between a law and a God of grace. We all believe that the law came from Moses, while truth cometh from Jesus Christ. In the theological custom, the law and the grace of God are not antagonistics, but they are separate. And those who are believed to be gods of the church, fathers of the church, they were believed to be teachers by Christ. Teachers in the ancient Greece were slaves that would take the child to school. They were not to educate, but they were to take the child to school and make sure that the schooling takes place. In the Christian culture, a certain secondary level of the God of grace is there, but it doesn't mean an antagonism between law and grace. In Russia, of course, the main book for the Russian society used to be Metropolitan Ilarion book on law and the God of grace. The title alone actually describes this conjunction. What is so unique of Russian culture is that the points of stress between law and the God of and the God's grace always emerged. There is a Russian saying, how should you be judged, by law or by conscience, we say in Russia. I may be correct. See, I'm sure Germans would say by law, while the Russian would say by conscience, while the Americans will never understand the question, because there's no similar differentiation between the law and the conscience. As someone who studied the United States culture, I know that this kind of segregation is unknown to Americans. Even semantically, I wonder how interpreters are doing in the booth. But the Russian notion of justice or equity semantically very different from English understanding of justice. Semantically, they are very different, and this is very significant. And now let me proceed to the most problematic issue. I'm taking you directly to modernity and our understanding of the legal nihilism in the Russian society, and to the extent to which it is related to all that I postulated before. Some argue that it is directly related to that. Others believe that the legal nihilism, if it is a there, and I'm sure that to a certain extent it is there. Some think that there is no direct link to that. I actually don't see the direct link, but you can't really ignore some of the postulates that I tried to describe before in a situation where we had in our culture two of these categories present side by side when we were accepting both the law and the God of grace. That is, I'm talking about the time prior to 1917. The secondary nature of law could be balanced, compensated by the search for the God's grace. I'm only philosophizing here. I'm not idealizing. I'm not trying to present an idealistic image of any specific historical period, but there was certain value-based balance in a situation when this was declared a legacy that should be abolished, something that the Soviet people no longer needed. This attitude towards law as something secondary became vulgarized exactly after this balance disappeared, and there was no longer balance of values because a very powerful deterrent was taken out of the set of values, and that's led to to this legal nihilism in the modern society. Let me, in conclusion, offer you two comments. In terms of the Christian religion's take on the law, despite the segregation between the law and the grace of God, Christian culture and the Russian Orthodox Church were never negligible or disrespectful of law, and the educating role of the Russian Orthodox Church could well be beneficial if we want to improve legal culture and eradicate so negative components which is or that legal nihilism is about. And in postscriptum, which is slightly unrelated to all previous comments, but I want to, in this distinguished audience, to draw attention to a document that was created by the Russian Orthodox Church a few years ago, in 2008 to be precise. It's called On the Fundamentals of the Russian Orthodox Church Teaching on Dignity and Human Rights. It describes the attitude of the Church towards the concept and practices of human rights. It's very far from certain media-accepted precepts where the media argue that the Church is dead against the human rights. This is a very important philosophical, theological, and practical document describing very important elements of our modernity, which is human rights. And of course, I'm here for your questions, and I would love to offer more comments if I could later on. Thank you very much, Vladimir. Do we have any questions to Vladimir?
What legal legalism in Russian is, because I simply don't know. But I know quite well that conscience and morality for Kant was, of course, linked to law. So my first question would be, in the century of Enlightenment and in the influence of legal education, I can't see the difference between conscience and law. Second question would be, you see, I'm a Christian, I'm a Protestant, not an Orthodox. But going back, let's say, to the question of religious obligations and human laws, there is one interesting point in the history of my religious education as a Protestant. In medieval times, Christians, of course, were obliged to implement charity. But they did do that because they wanted to go to heaven as a Christian obligation out of their conscience. Today, we say in the secular state that every human being has a right to live, to limit state and political power, and to get some human rights as a minimum. Why is this legal nihilism? Or did I understand it in the wrong way?
Спасибо большое.
Thank you so much. Well, we believe that Kant was a Russian Orthodox. Well, it's a big joke. Yeah. But well, it's great if they quote me that professor of Gimao said that. It's great. No, it's a joke. But I would, with great pleasure, ask you the same question, because I was interested, because this position of Kant, as far as I know, and his categorical imperative and all the genius creative work is connected with all this interconnection of religion, ethics. But the idea of God, Kant's idea of God, is far from dogmatic Christian perception, and this is a moral moral argument of Kant, and which is something that is the inevitability of human existence. It is not by chance that you mentioned this collective contract that emerged at the time of Enlightenment. So all those matters emerged in Christian culture, but they are actually far ahead of early Christian perception, and everything that was created before mature. So Thomas Aquinas, of course, said a lot of different things. It's different from Kant. And if I understand your question, well, when did we get that division of consciousness and the law, and why did it emerge? I'm not ready to tell you about the reason. If you disagree, when we ask the Germans this question, how to judge you, by law or by conscience, and maybe this is a low point in my thinking, but it seems to me that this is part of national culture, part of national special features, also special national understanding of Christianity. And regarding the second question, well, by legal nihilism, I meant, I'm going to quote, if I may, please allow me, distinguished moderator, I don't agree with it, and maybe I disagree with it, but this is the idea which is in part connected with a Russian perception of law. Maybe it's not domineering, but it's present here. The perception of law in Russian by part of Russian society. Russian movie director Zvягintsev, who recently presented his movie Leviathan, and in his interview he writes the following. When we have a rebellion, it's a force of nature, something irrational, and Pushkin said that it was senseless. But Russians are patient, but they become they don't feel that they have the right to do anything. It's easy to convince Russian people that they don't have the rights. It's in Russian DNA. Americans feel that they're self-made people. Americans love freedom, and they feel their individual right to do anything. But it's not fair to say that Russian people don't love freedom. Russian people love freedom, but there is some difference. Well, we are not lawyers. We cannot provide exact wording. The freedom is not the right which is guaranteed by the Constitution or the laws of state. The Russian real conditions, they allegedly take away the right of the Russians to have any place under the sun. But I believe that we must have a really vivid discussion. So I don't agree with that. I tried to answer your question, not answering your question at all. That's very good, colleagues. Now we have some intrigue and some intellectual provocation. And you remember what Bismarck said. When you make your presentation, you must be brief and you must offend a lot of people. Well, at least you were brief. And now it's good that I managed to do it before the minister. But now the minister is here. I'm really happy that you didn't listen to my presentation. Well, colleagues, now we can proceed. I would like to give the floor to Sun Zanin, Director of the Department of the Work of Legal Aid, Minister of Justice of China. We are really happy that you are here. You have the floor.
Respectable Chairman, ladies and gentlemen, and dear friends, good afternoon. Chairman, ladies and gentlemen, dear friends, good afternoon. I'm very happy to have this opportunity to come to the North City of St. Petersburg to participate in the 4th St. Petersburg International Legal Forum.
好，圣彼得堡国际法律论坛创办的时间虽然很短，但前景广阔，已经成为各国加强国际司法交流与合作的一个重要平台。
Even though the St. Petersburg International Legal Forum is young, but we have seen its great potential, and it has become an important platform for international legal exchange and cooperation.
本次大会围绕法律体系中的法治概念、关键要点和未来展望这一主题，为我们提供了一个与各国代表进行深入交流的好机会。
The concept, the main idea of this international forum, which is the rule of law in legal systems, key takeaways and prospects, provides an opportunity for our in-depth communication.
会议主办方安排我在法律的概念、关于法律观点的哲学单元发言，下面我就主题谈几点想法。
I'm very happy to have this opportunity to speak to the subject of this roundtable, and now I'd like to share with you some of my ideas.
法律是人类历史发展进程中的重要精神成果，在调整和发展社会关系、保持社会稳定中发挥着重要的作用。
The law is the important spiritual achievement of human history, and it is very important in adjusting the social relations and to keep the stability of society.
法律的生命在于实践，通过联系法律实践，有助于我们从更深的层次把握法律的概念。
Because the law is living, so we have to closely connect it to the practice in order to deeper understand the concepts of law.
具体来说，我想从法律援助的视角与在座的各位进行探讨与交流。
So in my today's speech, I'd like to discuss with you about the concept of law from the perspective of my work, which is legal aid.
在中国，法 法律援助是为经济困难的公民和特殊案件当事人提供无偿法律服务的法律援助制度，是中国特色的社会主义法律制度的重要组成部分。
In China, legal aid is a kind of legal system to provide free legal service for people for citizens in economic difficulties and the clients of special cases. It is an important part of the socialist legal system.
中国是从1994年开始探索实施法律援助制度。2003年，国务院颁布的法律援助条例确立了这项制度的框架和主要内容。
China started to explore the practice of legal aid since 1993, and the State Council put forward the regulation of legal aid, which established the framework and main contents of this practice.
中国法律援助制度起步虽晚，但发展迅速。特别是伴随着中国依法治国方略的全面实施，伴随着中国政府保障和改善民生工作力度的不断加大，法律援助制度在维护和保障人权、促进实现公平正义、保障人民安居乐业中发挥着越来越重要的作用。
We start late, but we have seen very rapid development with the implementation of the national strategy of rule the country by law, and also our efforts to improve the livelihood of every citizen. The legal aid has been a big role in protecting human rights, to enhance the justice in the society, and to safeguard the well-being and the stability of the life of everyone.
第一个方面，谈一下关于法律人权保障。
First of all, I'd like to share with you my idea about the law and the protection of human rights.
法律制度是具有国家强制力、约束力的社会规范，它以最明确的方式对社会成员的言论和行为作出要求，实际也是对其他成员权利的保障。
Law is a binding social regulation. It has requirements for every member of the society. Actually, these requirements are the safeguards for the rights of others.
从这个意义上说，法律是人权保障的规范。中国政府高度重视人权保障法治建设，以宪法为依据，对生命权、人格自由和人权尊严、平等权利、政治权利、劳动者的权利、经济社会文化和其他权利做出了全面系统的规定。
Chinese government attach great importance to the protection of human rights, and on the basis, with the constitution at the basis, the Chinese government has made a series of legislations to protect the rights to life, the rights to freedom, and the rights to justice, political rights, the rights to work, and other rights in the social and economic fields.
法律援助制度在人权保障制度体系中具有独特的地位和作用。
The legal aid system plays a special role in this protection system of human rights.
法律援助贯彻公民在法律面前一律平等，国家尊重和保障人权的宪法原则，使公民不论经济条件好坏、社会地位高低，都能平等地获得法律的保护，彰显了社会主义法治对人权的保障和维护。
Any citizen, no matter what his or her economic conditions or social status, they are equally protected by law. This practice shows that every citizen is equal in front of law, and the protection of the country, of the human rights of every citizen.
特别是近年来，随着中国政府保障和改善民生工作力度的不断加大，法律援助覆盖面不断的扩大。
And in recent years, with the government attached more importance to the safeguard of the well-being of common citizens, the legal aid work is covering more and more people.
从法律援助对象看，覆盖人群从享受最低生活保障的群体， 逐步扩大至低收入群体。大家知道，中国是有13亿人口。
From the people who are receiving legal aid, we have those people. We have expanded our coverage from the people with minimum income to the people with low income.
从法律援助的事项范围看呢，在法律援助条例规定的请求国家赔偿、请求给予社会保障、待遇等6项基本事项之外。
For these cases, what cases that can apply for legal aid, we have besides these cases, which is stipulated in the legal aid regulation, which is national compensation and social security, and other 4 categories of cases.
各地还根据条例授权，以普遍将涉及劳动权益的保障、婚姻家庭、交通、医疗事故损害赔偿等事项纳入了法律援助范围。
Local legislations, as authorized by the legal aid regulation, has included the protection of labor rights, the family and marriage cases, the traffic accident cases, compensation cases. These cases are also covered. These are also included into these cases that are entitled to apply for legal aid.
全国每年办理法律援助案件，平均每年以16%的幅度递增。2013年办理案件超过115万件。
And the number of cases is increasing by 16% every year, and we are handling 1.15 million cases in 2013.
法律援助已经成为维护经济困难群众合法权益、解决民生问题的重要途径和手段。
Chinese citizens has already regarded legal aid as one way to protect their rights and to solve these difficult problems in social lives.
法律援助制度与妇女权益保障法等实体法、刑事诉讼法等程序法相互衔接配套，形成了比较完善的公民权利保障法律体系，成为中国司法人权保障领域的一大亮点。
Working together with the law on protection of the rights of women, and also work together with these procedure laws like the criminal procedure laws, the legal aid system has the legal system altogether with all these legislations has formed a system to protect the basic rights of Chinese citizens, and which is a very important of great importance in the protection, in the legal protection of human rights in China.
第二个方面，我讲的第二个方面是关于法律与公平正义。
The next point I'd like to share with you is about law and the justice.
公平正义是中国特色社会主义的内在要求，也是中国法律制度的价值追求，在立法理念、条文规范、法律实践等诸多方面得到了体现。
Justice is the inner requirements of the socialist with Chinese characteristics, and also are the value pursuits of the Chinese legislation, and in the ideas and the actual regulations and the practice of Chinese legal system, this idea is demonstrated everywhere.
经济困难公民的合法权益得到平等保护，是法律制度公平正义的重要标志。
That's the rights of the people who are in difficulties has been protected. I think it shows that it is the important signifier of the justice in the legal system.
法律援助通过依法履行辩护和代理职责，维护法律正确实施，保证案件的公正审理和判决，使那些有理无钱的人一样享受法律的公正。
Legal aid, through providing defense and representation according to the law for these underprivileged people, and to make sure that the laws are applied correctly, and to make sure that the cases are handled with justice, and those people who are underprivileged will also enjoy the justice. So I think it is very important in our legal system.
特别是在与公民生命和自由权利、基本权利密切相关的刑事司法活动中，法律规定特殊刑事案件的犯罪嫌疑人或者是被告人，主要是盲聋哑人、未成年人、限制行为能力的精神病人，以及可能被判处死刑和无期徒刑的人，可以不考虑其经济状况，通过公检法的机关的通知辩护，成为法律援助对象，获得律师的专业帮助，确保了刑事诉讼程序的正当性、合法性。
In criminal cases, which is very closely related to the life and freedom of citizens, we have stipulation in laws that these special criminal cases, the suspects of special criminal cases, and also these, especially those people who are deaf and they are underage, they have psychological problems, those people might be sentenced to death penalty or life sentences, regardless their economic conditions. Upon the notice of the prosecution or the court, they are entitled to legal aid and they can get the professional help of our lawyers, which I think it helps it greatly helps to make sure that the justice was guaranteed in the criminal procedure.
正是基于法律援助制度的深入实施，中国刑事案件的辩护率有了较大的提高。
Because thanks to legal aid, the criminal cases, most of people are properly represented by lawyers.
法律援助制度已经成为保障公民平等享有、平等保护、平等参与、平等发展的重要途径和方式。该项制度不断发展完善的过程，也正是中国法律制度对公平正义价值观不懈追求的生动诠释。
And I believe the legal aid system has an important way to guarantee that the every citizen in China was equally enjoy the access to justice and equally enjoy the possibility of development. And I think during the development of this system, it shows that the Chinese government is pursuing the value of justice in the efforts to perfect the legal system.
第三点也是最后一点，关于法律以依法治国。
The last point I want to share with you is about the law and the rule, the law and the rule of the country, the rule of law in the country.
法律因为具有连续性、稳定性、权威性的特点，是国家用以调整社会关系、维护社会秩序的重要手段和方式。
Because the law is consequent, is stable and authoritative. It is used by the country to adjust the social relationships and to maintain the stability in society.
中国政府在加快推进经济建设的同时，大力推进社会主义民主法治建设，提出发展社会主义民主、健全社会主义法治的战略方针，将依法治国确立为治国的基本方略。
With the emphasis on the economic development, Chinese government never ignore the importance of the rule of law, and they have made the basic national strategy to make national strategy to rule the country by law.
法治是治国理政的基本方式，法律援助在推进依法治国建设中发挥着重要的作用。
The rule of law is the one important way to good governance, and the legal aid will demonstrate its importance in our efforts in this respect.
通过及时为经济困难的公民提供法律帮助，引导他们依法 反映诉求，依法维护权益。
in providing timely legal help for people in difficulties and in guiding them to put forward their ideas and their complaints in a rational way. The legal aid has shows his importance in the rule of law of the country.
与此同时，法律援助借助电话服务、网络服务等方式，面向全体公民提供免费的法律咨询。
And at the same time, legal aid in legal aid system, we also provide free legal consultation to every citizen in China through hotlines and internet websites.
注重在提供法律服务的同时，开展法治宣传教育，积极传播法律知识和权利义务观念，既保障了
Because we know that the legal aid, the consultation of lawyers is important, but also it is very important to promote the awareness of law in every citizen.
既保障了公民合法权益，又增强了公民的法治观念。
And it is also an important way to help to protect the rights of every citizen.
2013年，法律援助机构共为627万公民提供免费的法律咨询服务，大量社会矛盾纠纷通过法律途径得到有效解决，有效促进了全社会形成良好的法治氛围。
In 2013, we provided 6.27 million cases of free legal consultation for our citizens and solved a lot of disputes through legal aid. And I think it helps a great deal to the stability of the society.
女士们、先生们，在几十年法治建设实践中，中国坚持遵循人类法治文明发展的一般规律，同时体现社会主义的本质特征。
Ladies and gentlemen, in these decades years of efforts to promote the rule of law and to construction of the legal system in China, the Chinese government respect the regulation of the development of laws, but also emphasize the socialistic fundamental features.
注重继承发扬我国优秀的法律文化传统，同时积极借鉴吸收世界优秀的法治文明成果，形成了符合我国国情、反映人民意愿、顺应时代潮流的中国特色的社会主义法律制度体系。
We attach importance to our legal inheritance from the history, and we are very eager to learn from other countries. So the Chinese legal system with legal system with socialist characteristics is up to adapt to the national conditions, and also is very up to the trend.
在此基础上，我们将通过圣彼得堡国际法律论坛等平台和桥梁，加强在法治领域的国际交流与合作。
And so on this basis, we also very like to use these important international platforms like the St. Petersburg International Legal Forums to enhance the cooperation in the field of rule of law.
不断为中国的法治建设注入新的活力，不断赋予中国特色社会主义法律制度新的内涵。
And I think it will provide new ideas for the construction of rule of law in China, and to enrich the Chinese legal system with Chinese socialist legal system.
最后，请允许我对俄罗斯政府为论坛所做的积极努力和周到安排表示衷心的感谢。谢谢大家。
The final, I'd like to take this opportunity to thank the Ministry of Justice of Russia and for their efforts to make this forum so successful. Thank you very much.
If we have any questions to our guest, please. Unless we have any questions, I would like to give the floor to Cosimo Ferri, Deputy Minister of Justice, Italy. Thank you very much to all of the participants, and I would like to thank Minister Konovalov for the invitation, his opportunity to meet with all of you, because this forum seems to be demonstrating through all the talks and conversations that I've participated in today, demonstrated the highest level of profession. It is a way to ponder on the ways that we all could follow to defend rights. It is of great interest for me to contribute to this panel on the notion of law, because when we talk about law, we always have to mention in the same breath philosophy and, of course, the Roman law. Let me remind you that the Russian Federation is one of the centers of the studies of Roman law. And it is one of the centers. The Roman law is basically the origin of everything that we have now in law. And from the point of view of philosophy, of course, we want to mention law and ethics. These are the two cornerstones that are side by side. I was privileged to read some of the papers presented by Minister Konovalov, for example, the origins of Western Christianity. We already mentioned the Western Christianity and how ethics includes human rights. Talking about ethics means talking not just about mores from the point of view of law, but also about application, about the precepts of the rules that may not be written, but the rules that we all follow in our education, in our development, in our conscience. That's something that all of us should have as citizens or as politicians or legislators. We should have the idea of moral duty, morals and ethics as the guiding star. We need to be clear how we should protect and defend rights in the civil law and the criminal process. And there are, of course, situations when you really have to ponder on that subject matter. Sometimes we could argue these are two segregated matters. For example, when we talk about safeguards, the Constitution of the Russian Federation could be one of the first to recognize the right to legal aid. And we've heard about that, this right to be defended, to be represented. My country, Italy, has only recently modified its Article 111, which concerns the effective right to be defended, the rights to be given to all, irrespective of their economic wealth or possibilities. In Italy, this right which is widely debated. There is a free access to justice. Of course, it is to be discussed in the context of economic conditions. The government often acts as a defender in that context. But because of some recent cases of violence against women, for example, we had to reinforce criminal protection or protection in criminal law in protest against violence against women. All victims and those who suffered had right now have now the right to defense, irrespective of the economic position. This was a major step forward compared to some of the fundamental approaches reigning before. Again, in the context of safeguards and we need to remember about the young people and everything that we must and need do to protect them, protect the minors in the context of civil law rights, so the rights to be given to the those who are underage, and this brings us to some matters of the criminal process as well. Italy is very intensely working on certain important reforms on separate jurisdiction relating to human rights of the minors, juveniles, and the related matters of family relations. In terms of human rights protection, special attention should be given to education and increased awareness. Certain rights should be given to all, and for the young people to be aware of that, we could make sure that they know about the inalienable rights, and this may help us combat crime. When we talk about ethics, we also think about the business, about commercial law, about commercial relations and business relations that help each country grow and help each country be compared and compete with other countries, attract investments. We, of course, are part of the European Union, but this is as important outside the European Union in all our global links and ties. And in developing contractual law, we need to consider ethical aspects in the context of trust and confidence between the contracting parties. When we contract each other, we invest in some business, we invest our assets. I want to be respectful of the counterparty and respect the principle of goodwill. I also must respect the social interests, and if we deal with specific industries, it's quite important for each country to develop if we all can we all take into special account the fundamental rights. I'm very grateful to Minister Konovalov, and I apologize if I mispronounced his name. You could call me Fabio Capello if you want.
When we are discussing certain matters, ethics allow us to deal with any kinds of reasoning. And in Italy, we are working in the field of transparency. We combat corruption, organized crime, and also when we discuss philosophy, I believe that everything that we're discussing that has its origins in philosophy proper regarding the punishment. The notion of punishment becomes of special importance because there are certain absolute doctrines that believe that you can combat evil with evil, and you can compensate one evil with another evil. And there are also some other more utilitarian doctrines that can see the means to use punishment in order to have some kind of prevention. And also we have the Enlightenment and utilitarian practical concept of guilt that was the foundation for the whole system of punishment. And at the time of when we're dealing with enlightenment, we're looking at some ways to amend the effect of crime, and the punishment was supposed to restore order through the system of relationships between the guilty and the victim. And because of this philosophic idea, because of this comparison debates, we get to the concept of general prevention. And in our country, in our constitution, we are discussing the notion of punishment. Punishment should reform a human being. And in Italy, we have a serious problem. We have overcrowded prisons. We are looking for alternative sanctions that could be different from imprisonment, that nevertheless could reform the person and could show the person that the person made a mistake, but that would allow the person to be reformed differently. That would provide the opportunity to exclude repeat crimes, and this progress and these values that actually protect rights of people. This is not just a philosophy, and it's not just comparison of the idea of punishment. It's not just good and evil, but also it's possible to lead our country, such a country as Italy, to guarantee people the right to have employment. As you can see, we can discuss lots of different matters, and we've been working at those problems. And regarding protection of rights, now we say that this is a brand new Italian problem. The length of the process, now these processes are too long, and when certain responsibility of the person is stated, and the person is convicted, often it happens too late when the person is already changed, because at the time of committing the crime, this person was different. Then 15 years passes, and the person can change in the course of 15 years. Marital status can change, anything can change, and Italy now is living through the great desire to reform its system, to provide some kind of extra new justice that could be practically applicable, but could provide for the inevitability. The law should be applicable, the law should be working, and the law should be working for the people. Now for 6 months, we have the presidency in Europe, and for us, it's highly important. European values are important values for us, and we ask Europe to look at all those aspects regarding human rights, legal approach to human rights. And in Brussels, or very often, they accuse Italy of certain measures. We would like everybody to look at the efficiency of these measures in order to for these elements to be reflected in different countries and could serve as compromises regarding the constitutional rights that unite all the countries. That's why we believe that it's highly important to work also forming the legal culture, because the higher the concept of law, the more important moral, ethical, philosophy values are important for us. Maybe we should come back to Roman law in order to highlight the issues that are political. For example, the right to live, also the right to kill yourself, or also some ethical measures. And there are different legal cultures here, and lawmakers, Italian lawmakers, they don't determine certain matters clearly, but these are very sensitive issues that later could be interpreted by different judges, and the judge who is interpreting the law, the judge shouldn't create the law, but the judge should skillfully interpret the law in order to provide for the right balance between judicial power and also executive power. We have the division of powers. This is the foundation of our balance in Europe. In particular, we have to strengthen the feelings that people have regarding the strength of law, and this ethical culture should be inside the human being, and the human beings should share it, because it could influence positively those people who are going to make decisions and create laws. A lot of elements exist, a lot of elements regarding this broad issue that we are discussing today. We can be talking here for the rest of the day, because in the changing world, these matters may unite us facing globalization that shouldn't impose fear. But now I would like to discuss the issue of pre-trial detention. When we're not, when we put a person in jail before the trial. And in Italy, we try to revise the approaches that could lead towards better situation with prisons and jails, because we have our prison and jail population is too large. But we should remember about human rights protection. And also we try to decriminalize some of the crimes, smaller crimes, and also in Italy, several months ago, we introduced for the first time home arrest. And for example, for sick people, drug addicts, they could be put in specialized medical institutions, and it's a step forward. In civil law, we are looking for alternative measures of dispute resolution, such as mediation, and we provide the judge some alternatives that could be used. And it must be understood not as diminishing of the role of some rights, but we must know that some rights could be protected without a trial, but people must believe in alternative means of dispute resolution, especially because there is certain competition among different institutions, and quite often the outcome would be the same. It would be as efficient as the outcome of the trial. I don't want to speak a lot about it, but still, I'm going to tell you that we are going to improve all these alternative dispute resolution means to help the development of trade. If you have any questions, I will be happy to answer those. Once again, thank you for your attention. And I would like to emphasize that we want to guarantee the access to justice for everyone. No matter what kind of disputes you face, but accessibility means speed, means quality of judicial rulings. And this is something that we are discussing here, and we are looking with great interest at the reforms that happen in the Russian Federation, in other countries, and we would like to discuss it more and get more cultural and legal knowledge to make Europe stronger. Europe is going to be stronger only if it's capable to have dialogue with those who are not Europeans, but who have the desire to cooperate in order to protect the rights and to protect progress in the development of law, uniting us all. Sorry, I took too much time. Thank you. Thank you, distinguished colleague. I can see that you have questions. Professor Aleinik wanted to ask a question. You know, distinguished colleagues, I'm a little bit confused. I'm a little bit confused when the law wants to get to religion and to moral. Well, I am as confused as Ms. Dobler-Gmelin may be. I would like to ask you, what is this urge? Do you recognize the weakness of law? Maybe you think that law has a lack of motivation, and when the law is coming to even more informal institutions such as ethics or religion to find the grace of God and good for all, maybe it loses its foundation. Maybe everything becomes even more vague, at least in continental system of law. Or maybe it's some search for the basic roots. We're looking for something which is going to strengthen us. What is it? Do we recognize the loss, or we try to find the basic roots? Thank you.
Thank you very much for your question, because è molto interessante.
Well, it's a very good question, and I must tell you that I'm talking about Italy here. When I think about Italy, I believe that sometimes law is too weak. You touched upon a highly important moment, because when I discussed the right to life, euthanasia, also we can mention abortions, and this abortions issue is of special legal nature in Italy, and in some situations it's impossible to make an abortion. There are laws, and the laws they show the judge some kind of a way. But recently, regarding euthanasia in Italy, we discussed the case in Glara case. I don't know whether you girl for many years. She was at a terminal stage of disease, and her father asked to disconnect the cable of the medical equipment, and it made it all the way to cassation. And the question was asked whether there is the right to interfere with clear legal means. I'm a Roman Catholic. I practice. I don't want to give you some ideas, Catholic ideas. It would be wrong. But you touched upon a very important issue. The lawmakers must make the choice, and then the judge must follow that choice. For example, fiscal reform, tax reform. It's necessary to pay taxes. This is the right and the duty. We have very complicated tax legislation, and the judge, when the law is not clear, like I'm a member of the government and as a deputy minister, but my profession is judicial profession. I used to be a judge, and for me this issue is highly important. For me, the judge is substituting the lawmaker. If the law is not clear, if there is some space for flexibility, I have to make a fair decision. I must make the decision about paying taxes, or some decision regarding customs duties. And also I have to make the decision regarding banking institutions paying something because they invest in some humanitarian fields. And when we're talking about taxation and protection of human rights, I try to explain to you that we always encounter this dilemma that you emphasized. When the provisions are not clear, the role of the magistrate, the role of the judge must be used to fill in the gaps, and the ethics become of fundamental importance. It could be common sense, it could be moral feeling, it could be the ability to understand the consequences of making this decision. But I understand that important steps must be made in this direction. At the European level, international level, problems might seem to be more simple, but I believe that a lot should be done together.
I'm hopeful that due to the Italian presidency in the European Union, we'll be able to create an impetus inside Europe as well as outside to achieve some success there. But politics should take the back seat here to allow the concept of law to develop that would go above all these legal technicalities. I also believe that we have much in common in our understanding. I followed what my colleagues were saying. I agree with everything that was postulated. I may not be very good in answering your question, but the question was very complicated. Thank you. Thank you very much. I'm not sure I've got the answer to your question, but your question will help me to try and articulate better my own ideas. You've raised a few issues at the same time in your question. I can't comment the link between law and religion. What I wanted to say, there's a standard error by a historian who tries to explain 12th, 13th century from the position of his own time. I alluded to the Moses 10 commandments because at that point in time they combined both law and ethics. From the historical point of view, it is important for the law to consider the history of religion. The same is true as far as theology is concerned, to know what Marx or Hegel said. Historically, there is a genetic link. From the practical point of view, what I wanted to say, probably I wasn't articulate enough. As far as my understanding of modern law goes, almost as Dr. Watson to Sherlock Holmes, I don't see there should be any direct overlapping between law and religion. Like science and religion, we shouldn't confront them, we shouldn't antagonize them, but the system of values are important that should be shared, and this is one thing. And secondly, what I wanted to say, in my practical job, I face issues and challenges that can't be resolved through law alone. Certain legal precepts may be conflicting with my religion. Some European countries have legalized what for a Christian person, Catholic or Orthodox, should be a sin. Sin is not a legal notion, and it shouldn't be a legal notion. We don't have a theoretical issue here, but we have a practical challenge here. But if we accept this as legally allowed, citizens of a certain country may be protesting against it. This is the issue we need to address. We see that law is conflicting with some traditional notions of the large brackets of society. And this is what happens. We had massive demonstrations recently in Paris. This is a real issue, a real challenge. This is what I wanted to say. If I had an answer to your question, I probably won't be with you, but somewhere else, more important. But we need to appreciate this as a serious challenge which cannot be addressed through academic discussion only.
See, I was in Yemen 4 weeks ago and had a really interesting, deep discussion about the questions of religion, morals, and law. And I found it most enlightening when a very interesting and a very learned imam asked me, well, you in Germany have so many Muslims. Why do you dare to ask them to have a laik state marriage? Because a true Muslim must not have that. So you see, we don't have the time to discuss this, but I only wanted to say I allow to differ. Thank you so much.
Alexander, it's your turn. I would like to introduce the Minister of Justice of the Russian Federation. Thank you very much. Distinguished moderator, I would like to start with a word of thanks to the audience, to the panelists. It's my great honor to be joining this distinguished audience of panelists, very respected professors of leading universities, justices, and our distinguished foreign guests and participants. It is extremely important for us to make sure that our colleagues from China, Germany, Italy, United Kingdom to be joining us in discussions. They represent the largest economies as well as the leading legal systems, which may be neighbors or be based on very powerful systems of philosophy with very deep-rooted traditions in their respectful countries. And every presentation, any contribution is very cherished, and discussion of shared philosophical approaches to the law, both from the academic as well as practical point of view, is essential for this legal forum. The number of roundtables at this forum keep growing. We seem to be going into more and more detail, and this is a very meaningful act. But if we don't want to be following some of the fallacies that I used to criticize, I still believe that every year some 2 or 3 roundtables should be dedicated to philosophies, notions of law, concepts of law. Importantly, we seem to enjoy a lot of interest from the audience. This is a very lengthy preamble to my contribution. I'm not here to fully exhaust the subject. It's inexhaustible, but I don't think I could even make a completed, full-fledged presentation. I commented on some of the aspects of this issue previously. Let me just follow up on my own presentations in the previous years and probably touch upon some specific aspects. When I will be ousted from the government service, I may be allowed some time to write a book, or probably even do something in a more presentable format. At least I will have more time to accumulate the material. Again, to be consistent, let me remind you what we were talking about in the previous years. We were talking about atomization of the society, about the loss of a certain consistency in the society, when the man now is getting more and more a very important attachment to computers. We seem to get some more and more interesting subject matters in law that are of interest for very narrow academic interest. They're important for our understanding of law and of the practice of law. What can I add to that? This sort of development of tools, making it more pragmatic, making law more pragmatic, is fully in line with postmodernism tradition, where we intentionally refuse to look into the sources and origins and concentrate on details and manifestations. This is also in line with the tradition of St. Augustine, who said that conscience came from God above, and man must accept what he is given. And if he's given something, let not concentrate on that. Instead, let us do something more practical and develop things that are more in our grasp. This kind of approach is acceptable as philosophy. Today, pragmatization of lawmaking, it's more straightforward, simplified, and it may be called upon not so much by philosophical, conceptual approaches, but purely by our practical needs. We also were talking about globalization of law, not so much from a point of view of significance of global institutions, global approaches to the practice of law, which we try to harmonize. We're talking here about globalization of demand for law and lawyers. And one of our today's morning roundtables on arbitration, Mr. Hoffman, UK arbiter, formulated some of the things that for a traditional lawyer educated in the continental law tradition somewhat would be very alien. He was saying that today there are demands for different types of law and law enforcement. Some most respectful jurisdictions trade in their product and import aggressively. Sometimes they impose on the users. You may like or not like it, but we should accept it, that law can be traded in as a commodity, not only the rules or standards, but approaches, certain elements of the process, particularly in arbitration. We have demand for certain services in contract law and dispute resolution. So it is a very utilitarian approach. If there is demand, there is supply. You may like it, you may not like it, but this is reality. You probably have to accept it. There's nothing bad about it unless this product is not good quality. This product should be based on some important postulates underpinning pillars. It is useless to say that we have our own tradition, we have our own legal imperative. You don't try to impose your British trade codes. This is not an approach that would survive. You will be looking for a better, more competitive product, and this, when our businesses will be allowed to shop for the jurisdictions, laws, and governing law, they will be doing that. So you should be prepared that this is a very much common humane approach today. It's another matter that during this globalization of the demand for law and legal services by different interests, and these interests and subjective rights seem to be multiplying almost as an avalanche, as a plasma. During this global service, we could face the dilution of legal approaches, legal pillars, and instead of the origins of law, we face mechanical cooperation of different legal practices that override codification. What else I should mention as an important phenomenon, and we've been talking about the rule of law, which is of course something that we all accept now. But what is happening inside that law? What side of what kind of law is to be accepted as ruling? And it appears today we still see certain sacralization of law, including in the context of the rule of law, from the purely functional, ancillary, accessory point of view. This is not a sacralization of law as a tool. We should be striving at sacralization of the human being, his rights, legally protected rights, personal rights by the existing institutions and legal tools. There's nothing wrong about that. Human beings are important, but of course individuals should be protected. And I'm sure in the majority of their manifestations, they should find this protection. The problem is that what we see is not so much sacralization of the best qualities of the man, but rather the qualities that we see today, which are sometimes quite imperfect from the point of view of ethics, traditions, and customs of behavior. In this imperfect state, human beings are still considered to be almost sacred and be an object of protection. It means then that we will no longer be trying to improve the man and would accept the need to protect and secure and support in every way this imperfect human being. This is a kind of a phenomenon that could be illustrated with just one example. Last year, this year, next year, we will be having some very important anniversaries to celebrate. This year is, of course, the 10th anniversary of the Russian TV project, which we call House. Which is the same as the Big Brother in Western Europe. To save your time, I think the success of that TV project was because it tried to undermine the standards of the human beings.
I don't want to offend those people who are participants of that TV show and those people who enjoy watching TV, watching this show on TV, but the idea of the success of that, that's a very primitive joke. When the hares came to the swamp and decided to commit suicide, saw the frogs whose life was even worse, and then they decided not to commit suicide but to go on living because somebody's life is worse. So this is this kind of a TV show. We start a perception of the world the way it is, not trying to change it, not trying to improve it, but we protect the world with legal tools. For a long time, we have the legal theories that determine the law not just as some aggregate set of norms or principles, but the whole social fabric of law, everything that happens on law, all the legal relationships, all the deviations, all the reflections regarding the law, everything that exists that is of any significance to the law is supposed to be law. And the approach itself is not that bad. The question is how to set the priorities here. How could we look at the priorities when we're discussing different levels of law? There is a different perception of legal relations. There is a traditional Russian model of the theory of law, philosophy of law, and there was dual understanding of legal relationship. The ideal model, the way it was provided for, including the provisions of the law and the final result. And there was an attempt to compare the ideal relations and actual relations in law. Today, nobody recalls ideal relationship. Today, we're discussing something that we have in real life, what we do, what are the tasks of the judge, of the attorney, how to add it to those structures that still exist somehow in our codes and laws. In this respect, British English commercial law is much more interesting. It provides much better flexibility in the freedom of contract, economic activities, and if so, it's easier to use one of the existing models, and there are hundreds of precedents. In general, it doesn't lead to anything real bad, but the idea is that there is no holistic perception of law. And I believe that Constitution of the Russian Federation, which is 20 years old, provided great achievements in reaching that goal of the approach, and also Magna Carta, famous Magna Carta of England, which is going to be 800 years old next year. But in all those cases, systemic approaches, the idea was to have written law and prevailing written law. Unfortunately, a number of laws, also our constitution, all those laws show how high standards get into conflict with this lower standard of understanding the role of legal relationship. Unfortunately, the constitution in Russia was adopted 20 years ago, when it was really a difficult time in the history of the country, when people wanted to survive or protect themselves from outrage. No one thought about systemic development, and people understood constitutional standards differently. Also, some government officials believed that their task was to take the body of a dead person from one side of the street to another, to leave the body in the territory of a neighboring precinct. So those are bad examples, negative examples, something that we shouldn't have had. But in Russia, in the course of 20 years, Russia swallowed a huge portion of anthropocentrism. the portion that was consumed by civilized Europe for centuries, and we swallowed all that in the course of 10 years. Respect of people, freedoms, guarantees of rights and freedoms, but well, protein is also highly important and useful. But when you get too much protein, you get poisoned. I remember I traveled to Estonia in Soviet times, and I ate lots of whipped cream, and the consequences were really terrifying. I'm not going to describe it in detail, but and if I make those comparisons, let's continue. Let's talk about balanced nutrition. And if we can look at the same analogy, this is some kind of aggression and self-sufficiency of the person, which is also one of the incentives to follow the laws. Also, humans consume fat. People want to feel comfortable. They want to enjoy what they consume. But women can agree, well, I lost 15 kilos in 3 years. You can eat too much fat sometimes, and then carbs. It's energy of life. We become industrious. We work hard and long. But regarding law, you can compare, well, you can look at discipline, self-discipline, rational treatment, and there is the third element of nutrition, vitamins, and in our case, categoric ethical imperative plays the role of vitamins, and you can deal without it. Well, we can look at the balance of law and ethics, law and religion. But even in the textbooks of Soviet law, well, we had the same notions. And when we're talking about moral imperative, ethical imperative, in what is going to be the driver of that imperative, what's going to be the foundation. It's your personal business what to do. It's private. The result is important. Well, it's difficult to eat too many carbs. It's even more difficult to eat too much products, too many products with vitamins. But my idea is as follows: what we consume must be balanced. Everything that forms our personality should be taken in moderation. And I would like to talk about standards. I would like you to remember ideas about standards of law, the level of protection of general social values, and even if the law is supposed to protect corporate interests or the interests that we could call primitive, even in this case, the principles of law, the mechanisms of law should be whole. And the consumer of legal services should be expecting high-quality services, much higher quality than good pizza. And it must be easier for the lawyers to work. When a person is well-behaving, this person is going to be more law-abiding, will consult lawyers more often. But instruction is possible through your own example, which means we must provide such demand for the law so that the person, individual, should feel the inside of the process, not the outsider. So everything which is done by the lawyers is provided by legal norms, is making their life better. Today we have lots of well-developed legal instruments, communicative technologies, the market of legal services. People feel that they don't get active assistance of lawyers. The law is looking at high-tech elements. Also, the lawyers are looking for the highest income possible. And more often, the law is influenced by geopolitics, and also mostly because the rest of potential consumers of legal services, they don't see adequate reaction, adequate response to new challenges. They don't see real adequate answers to the new forms of outrage, diktat, getting invasion of privacy, and just a simple person, head of the family, pater familias, doesn't feel protection from aggression. The forms of aggression changed. They multiplied, and informational, culturological, criminal aggression, they multiply. They exist in abundance, but there is no adequate answer. And a possible answer that I could suggest to you is a representation of the responses that could be understandable to people in different formats and at different levels. We can have lawyers that help people, and also community justice. And in our country, it's community justice. It's somewhat lower. We're talking about the court of community and the judgment of your community, people's mediation, which is going to make legal conflicts more understandable, conduct prevention. And the law and implementation of the law should be accepted by people. And there is no contradiction here. I don't want the law to be some kind of the variant of a primitive TV show. I don't want everyone to feel an expert, but the person, citizen, an individual should feel that law is something comfortable and understandable. In Russia, we had such a dichotomy of law and simple justice. You can remember the attitude of peasants to the just steal from the state or steal from the neighbor. You cannot steal from the neighbor, but you can steal from the state. It's okay. It's just something quite acceptable. It's many centuries of stereotypes. I don't have to follow the law because nobody follows the law, and my rights are violated all the time. The government officials violate my rights, my neighbors violate my rights. I don't have to follow the law. And we'd better get rid of that stereotype as soon as possible. When you go from St. Petersburg to Helsinki, when you cross the border with Finland, you feel that even the worst Russian drivers, they start driving much more carefully, and they respect Finnish traffic rights. In the opposite direction, a Russian driver was in Finland, he was law-abiding, he crossed the border with Russia and he becomes a complete idiot. And why does it happen? Everywhere you encounter video cameras that control 98% of all the violations, and you can pay a huge fine no matter where you are if you violate traffic regulations in Finland, but you pay the fine and nobody is going to give you a visa next time to get to Finland, and people are motivated to follow the rules. It's quite clear that in Maslow pyramid, when you fear punishment or fear the lack of laws, well, it's one of the main motivators. And yes, the punishment must be influencing the person, must and my colleague from Italy was talking about new forms of punishment. Maybe in the future, when you deprive people of the right to use internet, it could be the same as imprisonment for some of the people. So it could be even more difficult for some people, the duty not to use internet. And there is another potential, another ceiling of legal understanding at the level of categorical imperative, at the level of understanding of the norms of the law, the notion of justice, of intelligence, good faith. This is the element of just self-implementation. And it could be widespread in Russia more than in other countries. And we have to use this potential much more. And we must implement it also in propaganda of the holistic law. And here, this is not the Holy Seat. Well, okay, this is the Holy so again, he is a representative of the religious community. So they say when there is bad company, they could destroy the best possible faith. But when we're looking at the moral provisions, the best philosophy, the best ethical achievements of humankind is not going to solve the problem in itself. This is an illusion.
The only way for Russia is criminalization. At many conferences and meetings, people suggest, let us legalize this or that, this punishment through administrative law or this punishment in the criminal law. But nothing happens as a result, because apart from the law, you should have certain practice. It will be utopian to revive the dichotomy of the law of nature and the law of positive. It is not all. It's not about this. It is more about the linkage between our ideal understanding of the law, the notion of the law, and the compliance with its principles. In particular, where we want to achieve uniformity, consistency, adequacy of law enforcement, and our adherence to the law principles, which should be the underpinning of the stability of our very unstable society. Thank you very much for your attention in this very important discussion. Thank you very much. We will take that as an important contribution. Could you please introduce yourselves? My name is Denis Struchkov from Roskapital. My question is to Alexander Vladimirovich. I want to praise the speaker. We've heard what we want to hear and what we have dreamed of hearing. my comments are coming. I'm talking on behalf of those lawyers that work with corporates. My question basically follows from that job of mine. I'm a lawyer representing business. When we discuss with my colleagues what is the direction that Russian law is following, in our community there's certain opinion that the Russian law is mostly to protect the vulnerable, the weakest, and the stupidest. You're very much regulated in everything that you do in business, because the preconception is that business is there to deceive you. For example, I'm coming to a travel agency, I read the contract, and I only refer to two specific paragraphs because there is the law, and I know that whatever they put in the contract, I will be able to appeal to the law and win. The same is true in your shopping. The bottom line is that many people sign the contracts without reading them. Because this is the habit, this is the tradition. You're very good in your metaphorical comparisons with cups and fads. I argue that this over-regulation is like fats that make you overweight. I was following one of the transactions of one of my relatives who bought a house for over $1 million without reading any documents. And he just lost $100,000 by not reading the contract. This is a very dangerous trend in the Russian law, I would argue. You said law is a comfort, is a zone of comfort for everyone. And I think this is a phenomenon that should be clear to all, and not only to those whom the government is to protect. I want to hear your comment. Are we right in our understanding of this recent trend in the law, and what should be a correction that the law should take in its development? Thank you for your question. It is a very philosophical question with some practical innuendos. I don't think I will give you a positive answer, because I only can give you a general answer. Again, appealing to what we were discussing this year, the year before. This is a balance between control and confidence. Any jurisdiction, any country tries to find this balance in between these two approaches. Unfortunately, some countries, and this country as well, we are an example of such a jurisdiction where this balance looks too contrasting, to speak mildly, with certain bias towards only one of the extremes. I think my answer will be on the principles of the chicken and egg. If we allow everything to happen on its own, but this can be done, but we all remember what happened 25 years ago. Making the environment more and more regulated is counterproductive. So again, I urge towards balance with promotion of private entrepreneurship initiative and encouraging sensible, reasonable behavior. But as far as law and government is concerned, and the society, same is true. We should have a system of certain pillars that we must protect and cherish, not in one single successful jurisdiction that we want to emulate would have none of such pillars. Take the UK, China, United States, Germany, other jurisdictions in Europe, they all rest on pillars. They may be masqueraded, so they may not look as portraits of leaders and schools and children as we are accustomed to see, but these pillars exist. I apologize. The media people are waiting for me. They're clamoring for my attention. I can't deceive them. Thank you very much. I, in turn, would like to apologize to Dmitry because he will have to be the last speaker today. But by way of apologizing, I should also say that it was his own request. He acted in all his modesty to be the last speaker today. It's my great pleasure to give the floor to the Justice of the European Court of Human Rights, Dmitry Gadzhiev. Thank you very much. I will be very brief. You asked me to make some brief comments, but make them provocative, and I'm here to do that. About the notion of law. For me, as a professional lawyer involved in these old questions and agenda for many years, I always thought that we are very important as lawyers. We do a lot of things. We consider various disputes. We write new regulations. But then I thought, haven't we been overindulging ourselves? I thought that the notion of law isn't self-negation. What I mean is this balance between the huge bulk of law, of law cases, of the huge number of prison populations across the world, be it Italy, Russia. Let me just to explain this idea, let me give you some examples of the earlier understanding of the notion of law. For example, it was conceived as the will of the domineering class. This is a bit obsolete now. We also wanted to regulate various relations, and was meant to be the notion of law. But this legal regulation leads to the restriction of freedoms and rights, and you will find that in our Constitution and the European Convention. The idea of law now is to protect fundamental human rights and freedoms. This seems to be nice and good. Can you feel the progress in this understanding of the notion of law? It could be there, but I argue against that. There's no progress because we tend to talk, be it the rule of the ruling class, which is all about violence, regulation of relations is disregard of human rights and the restriction, defense or protection of fundamental human rights is something that is just academical. We've just heard from our Italian colleague that women's rights are being violated all the time. In China, the government is trying to protect human rights, although their society is very monolithic, we would think. So what is happening, in fact? Since violence happens, and people continue stealing, and there are other things that are contrary to the notion of law. This all may be perceived as a reaction to violence or abuse. However, there was this golden rule once formulated in the Bible: treat others as you want to be treated by others. A very simple rule. With this rule alone, if complied with, we might argue we don't have the entire bulk of law, talk about global law, even if they're not exactly correct. People may be more merciful, pay slightly more in interest instead of disputing every figure. The crisis is ongoing. It is amazing. I learned that there are only 7 million disputes involving only those who are vulnerable. In China, in Russia, we have over 20 million disputes in court. The Russian administrative code is getting thicker and thicker by the number of various types of offenses. We may be exposed to at least once a year to various administrative offenses, major or minor, when the society is mistrustful, when people are lacking respect to each other, they face all these issues. And let me, in this context, respond to some of the comments I've heard. I'll start with the Justice Minister's when he described Russian drivers who behave much better in Finland driving their cars than in Russia. And he said it all down to the street cameras. I don't think it is correct. I think the driver crossing the border to Finland or going to other European countries, he had this perception: this is something you shouldn't be doing. This is not acceptable to violate, to overtake people in traffic jams. It's not accepted to, and this kind of atmosphere of inacceptability, the atmosphere of respect is very palpable, tangible. The same is true about some Russian institutions. You would find examples of this kind as well. And I fully agree with my Italian colleague here that education, enlightenment, culture are very crucial. Of course, when the minister, when he says that the human being is today, and what he meant, of course, the treatment of a criminal guilty of some crime. The dialogue that I see ongoing, and our Italian minister says we need to do our best to educate people, because it's the fault of the society if they haven't provided a necessary level of culture and education. It's the fault of the society that the person is not as perfect as we want to have him. And of course, some societies are more monolithic because they have some very deep-rooted traditions where brother want to go against another brother. It's unacceptable in these societies. In such societies, stability is more solid. As for religion and other values, I see some kind of a trend of trying to favor morals and ethics in favor of changing morals in favor of stability, making society more creative, make it reach values relating to some general understanding of what should be done, instead of intimidating by some consequences, the pictures of hell and so on and so forth accepted in religions. Without education or culture, the human being cannot arrive at this understanding. So let me since we started with poetry, let me touch upon some issues of culture. The movie called Leviathan is about this strive for the better. People are doing their best to make the best, and they die because the society is struggling, because such people are always in small numbers, and it's very typical of the Russian culture. And as far as the Italian culture is concerned, and we heard that our Italian colleague complaining that the European Court on Human Rights has quite a few cases against Italy. But Italy is probably one of the very few countries that have created cultural values and their understanding of cultural values thanks to some of these cases. For example, those case of Lao Tzu versus Italy, Scardina versus Italy, and the yesterday's case Parillo versus Italy. To remind you, Lao Tzu case is the case on crucifixes in state schools and Christianity symbols. Scardini case is about the right to to participate in elections by convicts, and the case of Parillo is about the right to life of embryos. I know there was this initiative in St. Petersburg to draft a law that from conception, embryo is to be regarded as a living being. This initiative was not accepted in Russia, but it was accepted in Europe by 2 million people. Differences in culture and education and this kind of comparisons show where we should be striving for. Thank you very much. I see question we have, but we need the microphone. So we start with questions and then your comment, please. My question is, and my name is Natalia Levchenko from the Moscow University. My question is on the role of international and national courts. Dmitry, would you know of a case whereby the level of human rights protection is higher than the international standard? It's not an easy question. I can't tell you. I gave you the Italian example, which shows the supremacy of superiority. I can give examples of our compliance. I want to know if we could be any better. There could be examples like that. Let me tell you this. The issue, well, to rephrase it, in terms of per capita, we don't get too many cases for Russia. 20 million for Russia and only 12 applications last year. This has nothing to do in its balance.
Because these cases are the cases regarding several categories of citizens. Mostly these are minorities. There are different features such as convictions, gender, sexual orientation, language. They all they are present in the rulings of the court. But if one of the categories is excluded, I would think about some kind of a progress but they are not excluded. But I'm sure that the standards, I wouldn't say that there are European standards. We should strive towards those standards, or shouldn't. But we're talking about whether it's going to be good here. There are cases when we don't find violations. For example, the fate of children after parents got divorced. The judges are very pay great attention. These are traditional things. Thank you. One more question. 20 million cases, and they are examined by courts. Well, this protein-based theory of the Minister of Justice tells us that it's not the person for the law, but the law for the person, for the individual. And if the European Court established not correspondence with the convention, but this is the grounds for the ruling. But our judge is starting to evaluate whether it's higher or lower. Is it protection of human rights, not protection? Does it create problems for the judge? Should the judge every time just evaluate everything, or there is a good, formal, healthy approach? I will be real brief, if I may. I have to tell you, the judge and a lawyer must work to diminish the number of disputes. Here are the disputes. Why we made the decision regarding one dispute, and it's much better for it to help to solve 150 more disputes. Well, I think that's all. Thank you. And Yelena, I have a comment, optimistic comment. I have to tell you that a lot was mentioned here about very serious issues, and it's a sad picture. And I want to get to the beginning of our round table. When you discussed the idea of law and the fact that the idea of law is not exhausted and is of national nature, and I believe that our German colleague set the tone of our discussion, who said that the idea of law is good, but implementation isn't always there. And everybody present talked about issues and problems, but I noted for myself that everyone talking about problems, how to get rid of the gap in the laws, how to establish international dialogue, how to solve the problem of equity. Well, they always looked at the history, at the multi-contextuality of law, and that's why they started talking about ethical norms, about religion. That's why, because this rich history of law included all the layers. And it seems to me, I am an optimist. Everybody who was talking here, you are all keepers of this idea of law. It's highly important. And while we have this high calling of lawyers, so all those sad pictures, are not going to work. Everything is going to be much better. Thank you so much. And you actually finished our session, and you made a very logical conclusion, and I believe that we have to be humane. We've been working for 2.5 hours now, and please forgive me. Our wonderful theoreticians are present here, Valery Vasilievich, Andrei Mikhailовich, and Valentina. And I have to apologize. I didn't give you the chance to speak only because I am the speaker here. I am the moderator, and that's why I have to say, I'm sorry, colleagues. Thank you so much for your attention. This is the end of our session.